a panel of judges, and if I may say so myself, with a bit of humility, I was one of the draftsmen, knowing that in other countries there was no office of Deputy Chief Justice, decided in Kenya there shall be an office of Chief Justice to deputize the Chief Justice. In doing what? I'll leave my learned friend, Mr. Gobo, to deal with that. But let me, in the 2 minutes I've been granted by this gracious lady, make 1 point, 2 points. Beneficiaries of ex parte orders stand before this court and say only they are entitled to ex parte orders. They are here to complain that they went before Judge Mongo, they went before Judge Muita, they got ex parte orders with finality, and that was okay. But when the Attorney General went ex parte, and all her prayers were refused, except the prayer to send the matter to the Chief Justice, she was wrong. How is that possible? My lords, I want you to remember, because it is in your file, the transmission from Kiraguya is in my learned friends are saying they have never seen the portal itself. Yeah? The registrar in Kirinyaga, Honorable Wanyama, writes a letter, yes, saying, "Good evening, kindly find attached the document for your attention. It has a time to the Chief Justice. It is on the 18th, and it is 15:45. It is 3:45 in the afternoon. So when counsel repeats again and again, things were done at night. Well, a lie can go halfway around the world before truth wears its pants. It is not true. It is not true. The registrar sends the order at 3:45 in the afternoon. I stop there so that my learned friend will continue.
Thank you. My lords, I will take it up from there, and I will dive right into the constitutional questions. The application before you for challenging the empanelment of this bench addresses itself, my lords, to the powers of the Chief Justice under Articles 161, 2A and B, that establishes the office of the Chief Justice as head of the judiciary and of the Deputy Chief Justice as the deputy head of the judiciary. And conversely, my lords, to Articles 163, 1B, that again provides that the Deputy Chief Justice shall deputize the Chief Justice and be the Vice President of the Supreme Court. My lords and your ladyship, it is now beyond peradventure, and again quoting from the CTS, that while counsel submitted that there may be instances of delegation, they ignored, my lords and your ladyship, that the law expressly provides instances or gives direction as to when the Deputy Chief Justice shall exercise the powers of the Chief Justice. And my lords, this is expressly set out at Section 5, subsection 2A of the Judicial Service Act, Cap 185B of the laws of Kenya. The Judicial Service Act expressly provides, my lords, that the Chief Justice can deputize or the Deputy Chief Justice will exercise the powers of the Chief Justice in the absence of the Chief Justice. My Lords, the CTS and my learned friend, Professor Gachagua, referred to this. There are only two professors senior counsels here, so it must be correct. My Lord, in the CTS, it is clear that the Chief Justice communicated to the Deputy Chief Justice that should be a way to Geneva, Switzerland, and Milan, Italy, between the 12th of October 2024 and 24th of October 2024. That is in the bank. It's in the bank. It's on record. It's on record. Senior counsel and my pupil master, Paul Mute.
Keep your voice calm. Keep your voice calm. There's no need to shout. I was asking the court whether this material is part of the court records or whether it is evidence. That's what I was asking.
You taught me to submit
politely.
You taught me to submit clearly, and I'm polite. Yes, I was speaking. My Lords and your Ladyship, it is therefore
that in my address to the court and indicated that the respondents in that application did not finally reply to that, through which this material could then be released before you.
My Lord, it is part of the record.
The material which is in the court portal is part of court record. If it is not on the portal, it's okay. If the material is in court portal, it's part of the court record.
Mr. Ndegwa,
just for good order, my Lord, because we access the portal through particular case numbers. In which case file is this material available that we can just log in and get to see?
My Lord, it is not in my place to start educating or demonstrating to my learned friends what file to look for. Because this is the portal. I would have had no other way of accessing.
Professor, can you just give us a reference?
Yes,
for purposes of clarity.
Yes, my Lord, 05, we have 3 cases that are consolidated. We have accessed the portal in E015 of 2024. A transmission from Claire Wanyama and E014 as consolidated. We have this material and they're aware of it. We have even gone further, my Lord, and served or passed on the communication to my land. It is the public domain, my Lord. We could not have secured this communication anywhere else.
Sorry, Senior Counsel, do you mean to say that what you're holding is filed on CTS?
It is.
Does it have a date and time?
It is the same way. What I have here is a copy from the CTS with a reference from the Chief Justice Office.
Are you able to tell date and time?
We only accessed it from the portal.
Yes. My request was straightforward. There's an internal memo we've just been given here. My colleagues are saying it's on the portal. If we knew the case number in which it was, we would have verified it. The other option would have been for my colleagues who are reacting a particular application this afternoon, have they found an affidavit regarding this document? The truth of the matter is that documents in the CTS have a timestamp, as my lady points out. The document we are having here does not have a similar timestamp. We're just saying, show us where it is so that we authenticate, then we make progress. It doesn't make sense to demean the rest of us when you have to authenticate. You do precisely that, you authenticate.
My Lord, I can confirm that it is even in the physical file. This document in the physical file. So that my learned friends do not have it, or that they are shocked that the Chief Justice is not in the country, should be a point for response. They can respond and say, we saw the Chief Justice around. That's a possible defense. My Lord, if I may, we are using into my time. They will have time to respond. Yes, the judicial report was. I can proceed.
I have a specific question. We want to know in which case file in the portal, because that's the submission my colleague has made, there is internal memo. First, I want to know the internal memos are normally in the portal. I'll be glad to learn. But more importantly, in which case file is this internal memo so that we can authenticate. That's simple. My colleague will say this in the portal. They are duty to furnish us with the particulars.
Yes, we have indicated, my Lord, that it is in the physical file. My Lord, Mr. Nyamodi will specifically address him to that so that I can proceed, my Lord. My Lord,
please, The applicants, when you are submitting, the respondents gave you time. Please just give them time to make their submissions. You are going to respond. There will be time for you to make a rejoinder.
My Lord, the proceedings before you are in the public interest. They are in the public interest, and therefore the question of time management, my lords, and the need for expeditious disposal of the application before you cannot be overstated. My lords and your lordships, time and again, Malawi friends have submitted that whereas this court can sit at odd hours where it receives an application, that in matters as mundane as the current matter before you, that this court should have had this matter in the course of the day. Of course, no doubt, my lord, this court has moved to the electronic age where matters are transmitted through mail and through other forms. My lord, but most fundamentally, we are here to challenge ex parte orders, not inter parte orders, not orders given inter partes. And Malawian friends therefore cannot speak from both sides of the mouth that where you are dealing with matters of the impeachment of the deputy president, such as this, that ex parte orders cannot be issued, yet they obtained ex parte orders that necessitated the filing of the application before you. My lord, what we are dealing with here is a removal under Article 145, and which the law defines as final under Article 145(7) of the Constitution. When therefore Malawi friends submit about the office of the Deputy President, they seem to forget that Article 145(7) refers to the finality of the Act of Senate. And therefore, all the orders obtained under the subject, all the orders obtained under the subject of this proceeding, my lord, were obtained after the impeachment proceedings, after the act of impeachment. And it is therefore important, my lord, in the interest of all of us, that these matters are resolved expeditiously and timelessly, so that this court can move to the next phase. And the next phase, my lord, would be dealing with the question of the next step. My lords and your lordships, it is clear that my Malawi friends do not want to proceed to that phase. And that is, we have all these multiple applications and the inability of the applicants to want to be confined to the question of time. They want to speak throughout the night. On our part, we want to sanitize this proceedings, my lord, and stick to the point that the application does not meet the threshold set out for recusal, because recusal is also a prayer in this. They have advanced no reason at all to want this court to recuse itself or to find that it was not empaneled in line with Article 161, 163, 52A of the Judicial Service Act. We opine, my lords, that this bench was properly constituted by the Deputy Chief Justice, exercising powers donated to her by the Chief Justice, unless they're saying that there's another Chief Justice. Thank you, madam.
My lord, my ladies, as a follow-on to the submission by my two learned senior colleagues, I wish to respond further to the application as follows. There has been a lot of water under the bridge since we convened, or since this court convened at about 11:15 or 11:30 this morning. But as I am no doubt members of the court will be able to quickly figure out, the single issue that is before you is a challenge as to the regularity of this, of the referral of the 3 or 4 matters to this bench. by the Honorable the Deputy Chief Justice, the Deputy Chief Justice of the Republic of Kenya. And I wish to commence my response to that objection by saying as follows. The Chief Justice occupies 3 distinct constitutional offices. 3 separate and distinct constitutional offices. First, the Chief Justice, by dint of Article 161, Sub-Article 2A of the Constitution of this Republic, is the head of the judiciary. By dint of Article 163.1, the Chief Justice is the President of the Supreme Court. And by dint of Article 248, Sub-Article 2E, the Chief Justice is the chairperson of a constitutional commission established under Chapter 15 called the Judicial Service Commission. Members of the court, I wish to take just a moment to demonstrate how the Chief Justice is deputized in these 3 distinct constitutional offices. In respect of her capacity as the President of the Supreme Court, Article 163, Sub-Article 1B is clear that the Chief Justice shall be the President of the Supreme Court, A, and that B, the Deputy Chief Justice shall deputize for the Chief Justice and shall be the Vice President of the Court. That is the first constitutional office. The second constitutional office is the head of the judiciary, and I will come back to Article 161 in a moment. Suffice it to say that it is in Article 161, Sub-Article 2, that the office of the Chief Justice is established. And Article 161, Sub-Article 2 states as follows: there is established the office of the Chief Justice, who shall be the head of the judiciary. I will come back substantively to 2B in a moment. But it is important that for the purposes of the commission established under Article 248, Sub-Article 2E, the Deputy Chief Justice is then not the Vice Chairperson of that commission. In the Judicial Service Commission, the DCJ does not deputize the Chief Justice. Now, it is our position for the respondents that the function that the Chief Justice exercises under Article 165, Sub-Article 4 is the function set out in Article 161, Sub-Article 2A. That is not the President of the Supreme Court, that is not the chairperson of the Judicial Service Commission, but that function is exercised by the Chief Justice in her capacity as the head of the judiciary. It is the Deputy Chief Justice who is the Deputy Head of the Judiciary. By dint of Article 161, Sub-Article 2B, can exercise the functions of the Chief Justice. As Deputy Head of the Judiciary. And Article 161, Sub-Article 2 creates 3 positions: the Chief Justice, the Deputy Chief Justice, and at Sub-Article C, it creates the office of the Chief Registrar of the Judiciary. Now, the Chief Registrar of the Judiciary doesn't deputize the Deputy Chief Justice, but the Deputy Chief Justice deputizes the Chief Justice. That does not require any interpretation. That is really comprehension as a matter of English. It is then for the Deputy Chief Justice, in instances where the Chief Justice is unable to act, the Deputy Chief Justice can then perform that function. In Lina Conchella is good law. And the facts in Lina Conchella are important. When you retire to consider your decision in this matter, you will note that the only respondent in Lina Conchella was the Chief Justice. The only respondent in Lina Conchela was the Chief Justice. If for the sake of along with the submissions made by our learned, then cannot deputize for the Chief Justice, then in Lina Conchela, when a judge of the High Court certified that the issue in that matter was an expanded bench under Article 163.4 or 165.4, then going by the argument, then there would be nobody to empanel the bench, because the Chief Justice will empanel a bench. That is the absurdity in the argument by the other side. And my Lord, it is our submission, or it is our position, that the Constitution of this Republic must remain elegant, and it must remain functional. Interpretations such as the ones urged by my learned colleagues for the applicants that would lead to that sort of an absurdity should be rejected by the court. It is my position, as I am on my feet this evening, as I have been consistent, that the Constitution says what it says. But the Constitution